Namaskar, welcome my friend. Today I am discussing Criminal Procedure Code 1973 and this lecture is related to principal feature of fair trial. What is a fair trial? What is a trial? And then after, what is a fair trial? The primary object of criminal procedure is to ensure a fair trial to every person accused of any crime. The notion of fair trial has close link with the basic and universal accepted human rights. It may, however, be noted that the fairness of criminal trial should not be measured in an absolute term. The question whether a criminal trial is fair or not will have to examine in relation to the gravity of the accusation, the time and resource which the society can reasonably afford to spend, the quality of the available resources, the prevailing social values, etc. In this lecture, it is attempted to give an overview of the common attributes of the fair criminal trial. First of all, discussing advisory systems. We have adopted advisory system of criminal trial based on acquisitorial method. According to this system, any disputes as to criminal responsibility of a person is to be resolved by the criminal court after giving fair and adequate opportunity to the disputant to place before the court their respective cases. The court is more or less an umpire and is not to take sides or to show any favor or disfavor to any party. It is only to decide as to which party has succeeded in proving its case according to law. The advisory system of trial enables as an impartial and competent court to have a proper perspective of the case, and it is believed that on the whole of this system is a better device to discover the truth in the fair manner. In our system of criminal trials, generally speaking, the prosecutor representing the state accuse the defendant of the commission of the alleged crime, and the law requires to prove the case beyond reasonable doubt. The advisory system as such recognize equal right and opportunity to both the parties, the state and the accused person, to present their cases before the court, but under the prevailing condition in India, the equal legal right and opportunity would in practice operate unequally and harshly, affecting adversely the poor, indigent accused person who are unable to engage competent lawyer for their defense. The system therefore departs from its strict theoretical passive sentence and attempt to provide legal aid and to state costs to indigent accused person to defend themselves in criminal trial. Further, their code requires the criminal trial to play a more active and positive role that a mere referee in the combat between the prosecutor, state and the accused person. For instance, the charge against the accused is to frame not by the prosecution but the court after considering the circumstances of the case. Prosecutor cannot withdraw from the case without the consent of the case according to section 321 crpc. Independent, impartial and competent judges. Second ground is the most indispensable condition for a fair trial is to have an independent and impartial and competent judge to conduct the trial. In this respect, the code has made the following provision: separation of judiciary from the executive. In order to ensure independent functioning of the judiciary in criminal matter, the code has brought about the separation of the judiciary from the executive by requiring the appointment of judicial magistrate as distinct from executive magistrate and bringing them for all practical purpose under the direct supervision and control of the High Court in each state. Because of the separation, no judge or judicial magistrate would be any way connected with the prosecution, nor would to be in direct administration subordination to anyone connected with the prosecution in a criminal trial. As the state in prosecuting party, it is of special significance and important that the judiciary is freed of all suspicion of effective influences of or control, direct or indirect. Second ground is court to be open. Public trial is open court act to check against judicial caprice or vagacy and serve as a powerful instrument for creating confidence of the public in fairness, objective and impartiality of the administration of criminal justice. The court therefore provides the subject in such reasonable restriction as the court may consider necessary. The place in which the court is held shall be open court to which the public generally may have access. Third ground is judge or magistrate not be personally interested in the cases. Nevodeb case, Nevodeb is judice to properia causa. No man ought to be judge in own case. The essence of the maxim has been incorporated in section 479 of the CRPC. According to this section, no judge or magistrate shall accept with the permission of the higher appellate court trying to commit from trial any case to or in which he is party or personally interested, and no judge or magistrate shall hear an appeal from an judgment or order passed or made by himself. In the present context, to more somewhat cognate provision made by the code may be noted. Section 352 has put on embargo on the trial of certain offences referred in section 195 and subject to the provision contained in section 344, 345, 349 and 350 by court other than the High Court where any such offence is committed before it or in contempt of its authority or is brought under its notice in the course of judicial proceedings. Section 480 provides that no pleaders who practice in the court of any magistrate shall sit as a magistrate in the court or in any court with the local jurisdiction of the court. Fourth ground is transfer of cases to secure impartial trial. According to section 191C, a magistrate empowered to take cognizance of offence may do so upon his own knowledge about his commission of any such offence. However, in such cases, the accused must be told before any evidence is taken and he is entitled to have the case tried by another magistrate. Section 191 CRPC. Secondly, whenever it is made to appear to the High Court that a fair and impartial inquiry or trial cannot be held in any criminal court subordinate to it, it may subject to the condition laid down in section 407 ordered that any offence to be inquired into and tried by any other competent court, that any particular case or class of cases be transferred from a criminal court subordinate to its authority to any other criminal court of equal or superior jurisdiction. Section 407 CRPC. Similarly, the power of transfer of case given to the Supreme Court and the Session Court by section 406 and 408 and very well be used in appropriate case as a means in securing a fair and impartial trial. It is interesting we note to the Supreme Court in a two important case in its power to transfer Jaira Vebola as Sheikh versus State of Gujarat. Both the state and material witness approached the Supreme Court seeking retrial as the trial was not conducted properly due to the witness turning hostile and the non-cooperation of the public prosecutor. The Supreme Court not only ordered retrial but also transferred the case to the state of Maharashtra. It is much interested to note that one of the parties in fact sought the transfer. Still, in the interest of justice, the Supreme Court did transfer of the case and it rejected the subsequent challenge its order on the ground that it was transferred with a prayer and hearing on the parties. The court asserted that the transfer can be ordered on the basis of relief specific as incident or ancillary to main relief. There was no need to formal applications seeking transfer. Second case is Ambedban versus Superintendent of Police. The Supreme Court ruled that party interested in section 406 subclass 2 would recompass political opponent of the accused, saying that they are the watchdog of the government in power. The petition in this case wanted the criminal case filed against the Chief Minister of the state to be transferred of the state. The Supreme Court order turned saying that the petitions had raised many justifiable and reasonable apprehensions of miscarriage of justice and likelihood of bias, which would require from interference in exercise of power under Section 406 CRPC. In Karnataka versus State and City of Delhi, the Supreme Court allowed the transfer of case under the SC/ST Prevention of Atrocity Act from the court because the negative remark of the judge regarding the misuse of the act. Fifth ground, competent judge made available through hierarchy of the code. Any overview of the provision regarding the constitution of criminal code will show their hierarchy structure given in lecture functionally under the code. The hierarchy is desirable and necessary for marshalling of the limited resources available for the administration of criminal justice. Complicated case of heinous offence would attract severe punishment, and therefore the case should be handled with great care by better qualified and experienced judges. On the other hand, in case of petty offences inviting only high punishment, it may be more expedient to have quick trial and speedy disposal, and such case can be conveniently handled by the subordinate judiciary. Section 322 and 325 also indicate the policy of making available competent judge for handling case in certain particular circumstances. Children below 18 years of the age accused of violation of law are not criminals, and therefore their case should be handled with a great care and understanding by experienced and qualified judge. Hence, Section 27 makes a special provision that the juvenile offender in respect of certain offence may be tried by the court of CGM, and in the absence of any special code established under the relevant statute, trial of rape case as per the particular shall be conducted by a court presided by a woman. Qualification of judge and magistrate. For fair trial, it is a primary importance that the judges and magistrates should be persons of integrity and character with the necessary ability and second knowledge of law. That the code was not make any specific provision in the respect expect the provision contained in section 13 and 18 in respect of the appointment of a special magistrate. All reasonable efforts are made by the state government and the High Court to recruit competent and qualified persons for the posts of judges and magistrates. In this scenario, this is some ground related to the principal feature of the fair trial. In further, some more lecture for judiciary and criminal procedure code. So please stay tuned. Jai Hind, Jai Bharat.